Welcome back to the courtroom, folks. And today's case is unlike anything we've seen before. A defense attorney accused of threatening the prosecutor's career right in front of the judge. What started as a legal dispute quickly spirals into a professional showdown, with Judge absolutely furious at what she calls inexcusable behavior. Stay tuned. This one's going to get heated fast.
Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
There were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why don't we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it set?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in tonight.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. and quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides,
Wow, the tension here is unreal. The judge just warned the defense attorney that she might grieve him herself. That's career-ending territory. You can literally feel the shift, from debate to discipline. This is one of those moments where the courtroom stops being about guilt or innocence and becomes a test of professionalism and ethics. Would you have handled this differently if you were in his shoes? Be honest. Drop your thoughts below.
her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in the.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice. not just with me, but with your ticket to practice. Court's in recess.
All rise.
Back on the record in the case of the people, state of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
The defendant. So it's very brief. And I don't want to have to bring the lay person back.
understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter.
In the end, the defense attorney admits he went too far, even promising to self-report his actions. The judge calls it what it is, a threat plain and simple, and makes it clear that no one, not even an attorney, is above the courtroom code of conduct. This case wasn't just about the defendant. It became a reminder that integrity in court is non-negotiable. If you found this breakdown as wild as we did, hit that like button, share your thoughts below, and don't forget to subscribe for more shocking real courtroom moments and breakdowns like this one.
Where confusion meets confrontation. Today's docket is stacked. From rent disputes and Section 8 housing issues to a shocking dismissal due to a legal technicality. We'll witness tenants fighting to keep their homes, landlords struggling to collect thousands in unpaid rent, and a judge walking the tightrope of fairness and the law. But just when things seem to calm down, a single mistake in paperwork changes everything. Stay tuned, because what happens next shows exactly how one wrong date can turn a courtroom victory into an instant defeat.
He's got $275 right now, but it's on his card. So he's going to turn that into a money order and drop it off. And this is the address you're going to drop it off. 206 North Huron. Take this. And then what he's going to do starting in June, he's going to start paying on the 5th of the month, $750 per month. His rent is basically $275. So by paying the $750, the first $275 will go to the rent, and anything over and above will go toward the arrearage. It'll take a while, but we'll work with him. He's lived there for a while. He's on Section 8. And this was the deal that we talked about last time.
Right.
And so I just need him to sign this conditional dismissal. And right there. And then the court will inform you of your rights.
Do you have any questions regarding anything on that conditional order dismissal, sir?
Yeah, He didn't tell me how long my lease up, cause man, I'm getting tired of what I'm staying with. They don't fix nothing and still got people laying in the hallways and everything. It's just a whole bunch of harassment. They hassle me over this money where it's been over like 3 or 4 landlords and they don't get in touch with nobody. But right now, Section 8 on them, cause they not fixing my place. And Section 8 involved and they trying to kick me out. And I'm like, they didn't even fix it what they gotta fix for me to even pass my eviction, to check the house out.
Okay, so do you want to
I don't
enter,
think-
do you want to enter into this or no?
I do, but $750, that's a lot. That's all my whole
Your
Social
Honor,
Security.
This is the same thing he did last time,
I
which
mean,
is,
I'm okay with it,
which
but
is weird.
I'm just putting the suggestions out there. Cause I only get my Social Security is only like $645, then I get $112. Then I got my tickets I paid off. I gotta find where to do the yard work for that. Washington don't do that no more. I got all this stuff on. That's just like it's okay. I can pay it, but I think that's too much. Even where I had to find a landlord and I got people on
If you're
my
not,
side.
but it sounds to me like you're not agreeing to this.
I'm
So-
agreeing to it.
Your Honor,
I got to. I ain't got no choice. I can't be kicked out. But I just think, what I'm saying, everything ain't my fault.
Your Honor, may I?
Yes.
Last time we were here, he complained about money that he thought he owed when Beal managed.
When I'm telling you now.
So I took that off.
Mm-hmm.
We got management back, MTH did, in December of 2023. Since that time, there's 18 months. He's made exactly 3 payments.
Because I didn't know who to pay it to. They
Well,
didn't tell us when they switched
I-
landlords. They didn't tell the whole business. Oh, we doing switching landlord like a business supposed to do. Here's the note on the door for everybody.
So if you want me to enter this, then I will. If not, and you're not in agreement, then I won't enter it. And I'll set it for trial.
But if we have a trial, it'll be a number and he'll have to pay it, because this is what happened last time, which is we came to an agreement and then we got to the podium and
I would say I'll do agree. I'm just saying, like, I just want to put my point across. I got the right to speak, but I just think, I'm gonna pay it. But
Okay, so you want me to enter this conditional order of dismissal?
he ain't gonna bring it down no
Do you
more.
have any questions regarding anything that's on?
No, that's it.
All right. Gonna sign off on this.
Just make sure he
3
can't.
business days to think about this. If you believe that there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion with the court within that time frame. That doesn't mean that I would set it aside, but you have that time to do so. You understand that?
Mm-hmm.
Okay, thank you.
thank you, Mr. Sears.
So it's 206 North Huron?
Court calls the case Sycamore Meadows versus Erica Jemerson.
Again, Carrie Zanon on behalf of plaintiff.
There she is. She was tucked away and back over there. Come on. Hello. All right.
So Judge, I just received the ledger as well. On this one, I'm showing $3,726, court costs of $190. So the total is $3,916. Ms. Jemerson, did you?
That's not true.
Okay. How much do you think you owe?
The judgment that you signed was for $2,400.
Oh, this is one that we've been carrying over.
Yeah, and then my rent is $0 since 2024, so 37. I don't know where that came from.
Okay, I signed that judgment that I signed back in, when did your rent go to 0?
September of 2024. They just making up numbers.
Ms. Jemerson?
All right.
I'm showing that she's $63, Your Honor.
Pardon?
I'm showing that rent is $63 for Ms. Jemerson.
Okay, but even if it's 63 as opposed to 0, I think what her point is how do I get to 30, what was it?
3,700.
Understand, Judge.
To 39, just so that clear, how do I get to 3916 when in February there was a judgment for 2414?
Judge, I will, can we adjourn this 1 week so I can go over the numbers with my client? And then I will hopefully have
I'll adjourn this then to March 20,
May.
2000 or 23rd,
You
2000.
said March, that's why. Sorry.
No, I was staring at the next date
I know.
after the February date.
Thank you.
May 23rd, 2025 at 3 p.m. Okay, and then let them take a look at where these numbers are coming from. But I get your point.
I will have,
Okay, thank you.
I will-
Thank you, Ms. Jimmers. Don't come in here yelling again. Like that, all right? You come back here yelling, we're gonna have a problem. You take care. You do the same. Let's call the case of, is it Shakes Corbin or Corbin Shakes? Corwin Shakes versus Bernadette Young.
Good afternoon, Your Honor. Nicole Jami, 85399 on behalf of Mr. Shakes. Apologize, my boy. I'm coming off of a cold.
Do that. Hello, your name?
Bernadette Young.
All right, this is a termination case. And where are the parties in relation to this case?
Your
have
Honor,
no idea.
Mr. Shakes is on via Zoom right now. He lives out of the state.
Yes. All right. There was no lease on this premises.
No, Your Honor. The notice was mailed to her on March 5th. We gave personal service of the complaint on April 22nd. We've given way more than enough time that's necessary under the law. We would just I'm ready to proceed with the hearing on this matter if it's necessary.
Well, except for the fact that she's a tenant at will or by sufferance. And I don't have the proof of service copy of the notice to quit, but you've indicated that notice to quit was mailed on March 5th.
That should have been in
And
the
if it-
packet.
But, okay, it's not there, but that's okay. I have a copy of the notice to quit, but not the service copy. But based upon your representation that it was mailed on the 5th, there's a problem because it indicates that she has to move by March 30th, which would mean she was not given 30 days.
Wait, hold on, Your Honor, hold on 1 second. We didn't file the complaint until April 22nd.
Oh, right.
Like
I get-
I held off on
I get
filing for
that.
that reason.
Pardon?
We held off on filing for that reason.
Well, that doesn't correct the notice. I understand you may have held off filing, but that doesn't correct the notice. The notice has to give 30 days. And the notice has to be proper for this court to have subject matter jurisdiction. The problem is by not doing that, I don't have subject matter jurisdiction over this at this point. And when I don't have subject matter jurisdiction, my only option at that point is to dismiss.
Well, wait 1 second, Your Honor, hold on a second. Let me just clarify something very quickly.
And here's where things take a legal nosedive. The attorney thought holding off on filing would solve the issue, but the judge catches a critical mistake. The eviction notice wasn't legally valid. Why? Because under landlord-tenant law, a 30-day notice must be precise. Even a 2-day error can strip the court of jurisdiction. That's right. The entire case collapses over a technicality. Imagine losing weeks of prep, fees, and filings, all because of a wrong date. This is courtroom precision at its finest. The judge isn't being picky. He's protecting due process. Would you call that fair or frustratingly strict?
Because that doesn't sound correct. Your Honor, can we have can we pass this very briefly?
Sure.
Thank you.
Ma'am, I'm going to pass the matter, so you can have a seat. Then I'll call you back up.
Okay.
Okay, thank you. Recalls the case, if they're ready, Corwin Shakes versus Bernadette Young.
Yes, Your Honor, Nicole Jami, 85399, again on behalf of the plaintiff. Your Honor, I see where the issue was. My assistant had sent it over to be delivered personally on the 28th, which is the date I authorized it to go. Did not mail it until Monday the 3rd. So the notice, yes, is off by 2 days. There's 28 days. However, we did not file this complaint until April 15th. We have email communications with Ms. Young about, she knew, like she was emailing back and forth stating, I received your notice, please give me more time, I'm looking for housing. And again, I know the notice is defective, but I'd please ask this court to recognize that she had noticed, she was communicating with us. My assistant had sent out, I'm sorry, I already said that, Your Honor, and I would just ask this court to please allow that.
Yeah, no, I hear you, counsel, and it would be an
Can we
invalid
amend it
judgment.
and can we adjourn and amend? Can we do that?
That the one thing that really cannot be corrected is the notice. Because that time period has to run prior to the filing of the complaint, but the notice has to, no, hold on. But the defendant has to have that time period in that notice. Right? So otherwise, quite frankly, from a practical standpoint, you would end up with 2-week notices to people because people can't get before the court till X time in any event. But so you have to give them a 30-day notice, then file. I understand, I think it may be a day, it may be 2 days, but that's the only way that this court can assume subject matter jurisdiction over the case is by the filing of a proper notice statutorily. So.
What a ride. From housing confusion to legal loopholes, today's session was a masterclass in how technical details rule the courtroom. The first tenant's emotional plea showed the human cost behind housing disputes, while the final dismissal reminded everyone that justice depends on procedure as much as intent. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real-life courtroom breakdowns, legal insights, and jaw-dropping moments caught on camera. Until next time. Stay sharp, stay informed, and remember, in court, every detail matters. Welcome back to the courtroom. And buckle up, because today's session is loaded with tension, confusion, and confrontation. From plea deals and missed sobriety tests to a defendant challenging his own lawyer, this one has it all. You'll see judges losing patience, defendants defending their honor, and lawyers caught in the crossfire. But the real question is, who's telling the truth, and who's just playing the system? Let's find out.
For drunk charge being dismissed, my client will plead to OWI first.
That's charged under the 93-day misdemeanor, $100 to $500 fine, 6 points from his license, and various other Secretary of State sanctions. Contrary to 257-62518, we'll dismiss the OWI high VAC. There had recently been not a violation, but a progress report cautioning the defendant to remain compliant with his SoberLink device. Mr. Shan had shared with me some of the explanation as to why there was that late/miss test. So I'm satisfied with that explanation and ready to move forward with this plea should the court accept it.
All right. And that's a correct statement of the plea.
Yes, it is, Your Honor.
Okay.
He cleans residential houses and he takes SoberLink with him. And he left it at a residential house that he cleaned and then had to go back and get the owner to get the SoberLink out of the residential house so he could do the testing. So that is what happened.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Aaron Salazar.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days of jail, a $500 fine plus court cost. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, I.
And to that charge, how do you plead?
Guilty.
Yes, I'm guilty.
You pleading guilty?
Guilty.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
No trial.
No trial.
That's the stuff that we went through. Yeah.
You understand that you will not have a trial, sir.
I'm sorry, Ross.
Do you understand there'll be no trial?
Oh, yeah.
All right. You signed an advice of rights form today, is that correct?
Mm-hmm. Yes, sir.
All right. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
You understand these?
Yeah, I understand.
All right, you understand you're giving up those rights?
Yeah, you're waiving those, you're giving them up.
Yeah,
Okay, is he understanding me?
Yes, you're,
Because I've got to make sure that he does.
yes, he does. And that's why I'm slowing down, because you speak really quickly and he does.
So that's the second insult Shan has given my court today. The first one when I wasn't out here, but was reported to me.
I did that.
No,
That is
you
not.
said
an
it, and
insult.
I know you said it. Now you just did that. Now that first one was about how hard I think I work my staff.
It was an honest,
And then this
honest
was just a
statement.
direct attack on me. All right, so no, I won't hold that against you. All right, but is he understanding?
Yes, he is.
All right. So you understand you're not going to have a trial. You're waiving all of the rights that are on this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah, I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No,
All right. Have you ever been to prison for longer than a year?
okay.
Have you ever been to prison?
Yeah,
Have you been to prison
the president where?
in the United States? Have you ever been to prison? Not jail, prison.
Yeah.
Okay. Counsel approach, please. Should reflect that it had a bench conference with counsel. I'm going to stop the plea at this time. I'm going to adjourn this matter out. June 4th, 2025, 9 a.m. And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you. Court calls case People versus Carl Tinsley.
People,
Is that what Johnson was here on?
yes.
Is that, you gotta watch, Alan, did you see him sitting over there in the corner? He was hiding. He comes in here and hides. Go ahead. Counsel.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Carl Tinsley, who's approaching from custody.
They're ringing. Your name, sir?
Carl Tinsley.
Thank you. Yeah, just step over. Yeah, there you go. All right. Okay, what are we doing?
Your Honor, we ask this matter be set for jury trial.
All right. Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor,
I'm sorry. What I'd like to speak about.
Okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
Jury selection
Yes, Your Honor.
before Judge Barr.
Yes, Your Honor.
It'll be here.
Okay,
We all select on the same day.
all right.
So.
Your Honor, if I may, so Mr. Johnson and I are at a fundamental difference in defense strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson remove his counsel in that case.
Why?
Excuse me?
Why?
Why? Because Mr. Johnson is.
Whoa, things just took a sharp turn. Mr. Tinsley is publicly accusing his own attorney, Mr. Johnson, of neglecting his case, calling him uninterested and unresponsive. But the judge fires back immediately, defending Johnson's integrity and shutting down the accusation on the spot. This is courtroom drama at its peak. A client losing faith in his counsel and a judge refusing to let the record show unverified claims. It's a reminder that trust between lawyer and client can make or break a defense. Be honest. If you felt your lawyer wasn't fighting hard enough, would you speak out like Tinsley did? Or stay silent and hope for the best?
I'm totally uninterested in this case, in that case, in this case
Okay.
as well.
Mr. Tinsley, Mr. Tinsley, you've been before me before, and I'm just going to tell you this.
Okay,
I haven't known Mr. Johnson necessarily all that long,
okay.
but I'm gonna tell you for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court where he has not been interested in their case and zealously representing his defendant. So I don't believe you. You coming before telling me that about this attorney? I don't believe it for 1 minute, not 1 minute. I think because you've been before, is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely
to the
wrong.
fullest.
I have not seen, this gentleman has told me he's gonna show up to see me countless times at the county jail. He has not. I've been waiting over 2 years for
what?
for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
He
done. If
is
you want to file
a tool for defense.
if you want to file, if you want to file drought, Mr. Tinsley, you're done. You're done. You are done.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter.
And that wraps up a wild session. 2 defendants, 2 very different outcomes. Aaron's plea got paused for further review, while Tinsley's emotional outburst nearly derailed his case entirely. From legal strategy to courtroom respect, today's hearing shows how quickly order can turn into chaos when tensions boil over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns, legal insights, and real-life justice moments every week. Welcome back to Courtroom Chronicles, where real cases meet real consequences. Today, we dive into a shocking plea hearing that takes an unexpected twist. Meet Harold Dennis, a man accused of holding onto someone else's car, not for a few days, but for 2 whole years. What started as a simple work agreement quickly spiraled into a legal mess involving larceny charges, confusion over car repairs, and questions of intent. Was this a misunderstanding, or a crime disguised as a mechanic's deal gone wrong? Let's find out as this courtroom drama unfolds. And pay close attention, because the judge isn't buying vague answers today.
That is our understanding of the plea, Your Honor.
Have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? God.
I do.
State your name.
Harold L. Dennis. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washington County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that, Did you have an agreement with him?
Yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long.
And how long is too long?
a couple years.
Okay.
2 years? Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the
So,
purpose of the
but-
plea, Your Honor.
So how long were you supposed to have the vehicle?
Well, there wasn't a determined time, but supposedly till I finished.
Till you what?
Till I finished the job.
What job?
You were doing work
I
on
was
the,
doing work on the car.
Oh, you were doing work on the car.
I'm,
And so then after you did the work on the car, you were supposed to return the car.
well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes.
And this, so that we're really clear, the work that you were supposed to do would not take 2 years to complete,
No.
would it?
No.
In fact, it should have.
So Harold claims he eventually returned the car, fully finished and in excellent shape, but only after years of delays and police involvement. That's like returning a borrowed phone after 2 years and saying, it works perfectly. Now, legally speaking, once the owner requested the property back and Harold refused or delayed, that's where criminal liability locks in. Judges consider the moment of intent, not just the final outcome. Even if the car came back shining, the act of withholding it without consent makes this plea to larceny under $200 a light tap on the wrist compared to what it could have been. Honestly, Harold got lucky here.
Been completed well before that 2 year period,
Yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
He did some
Okay.
work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after a few adjournments of the PCC.
and it was returned fully finished and in excellent shape.
But 2 years older.
Which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept a defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m.
10
a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date. Okay, and time.
And just like that, Harold Dennis's guilty plea is officially accepted, with sentencing set before Judge Washington. A case like this shows how thin the line can be between a business dispute and a criminal charge. The lesson? Communication and written agreements matter, especially when someone else's property is involved. What started as a car repair job turned into a legal battle over trust, time, and responsibility. If you found this courtroom breakdown as wild as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more real courtroom moments where the truth and drama collide every single week.